Hi, everyone. I'm Rebecca DeMarb. I'm a Senior Managing Director at Development Specialists Inc., DSI. I work primarily out of the Madison, Wisconsin, and the Chicago offices, although we are a nationwide firm. I've been serving as a receiver since about 2007. I've done it in state and federal courts. And before that, I was representing receivers as the attorney for the receiver. So I'm going to talk today about different types of receiverships. I'm going to hit the three main types that I see. But before we get to the different types, I want to stress that there's probably three commonalities to all of the receiverships, no matter what kind it is, that need to be paid attention to. First, again, no matter what kind of receivership it is, it's important to take a look at the state law or the federal law, whether that's a statute or common law and equity that underlies the receivership. The more I do this work outside of Wisconsin, the more blown away I am by the pure variety in the different kinds. So looking at the law itself is probably the number one thing to do. The number two thing to do is look at the order appointing the receiver. My order is currently over 20 pages long. There's all kinds of stuff in the order that sets up the receiver's duties and responsibilities. For example, some of the things my order covers is whether I have to file tax returns, whether I have to seek authority before paying or engaging professionals. Everything's in the order. So, reading the order is key. And third, no matter what kind of order or what kind of receivership, the receiver is an officer of the court with the fiduciary duties that are set out by the law and the order itself. So onto the three main types. I would, generically call them general receiverships, selfish receiverships, and receiverships pendente lite, which I've always pronounced wrong. But really just means during litigation. I'm going to start with the general receiverships because they're the juiciest and the most interesting. Again, these vary dramatically by state. In Wisconsin, the practice for general receiverships is old and very established. The law itself is based on the Bankruptcy Act. However, increasingly, states are going toward these general receiverships to be a state law alternative to a bankruptcy, and they're doing it by statute. So states like Minnesota and Missouri have both relatively recently filed or enacted statutes that provide for this process. In the general receivership, the receiver takes control of all assets of the debtor. The receiver's duty runs to all creditors and parties in interest, so not just to the secured creditor. These can be voluntary or involuntary. When they're voluntary, they act, they're founded in an assignment for the benefit of creditors, except with the receiver, obviously there's a court process and the receiver is appointed. The receiver always sells the assets in the way to maximize return to creditors. I would stress the goal is to maximize the net return to creditors, but there's always a sale. So unlike a bankruptcy, there's not a reorganization concept, although sometimes the assets can be sold back to an insider or group of insiders, and in that way it can operate almost as a reorganization by sale. These kinds of receiverships usually include a claim process. They often include the ability for the receiver to recover preferences and fraudulent transfers. But the biggest benefit is they allow for the sale of the business operating. That, of course, allows the receiver to capture the value of the operating business for the benefit of creditors, which can be beneficial in a whole wide range of circumstances. The sale process itself can be as complicated as a 363 bankruptcy sale with a stalking horse and sale procedure approval and an auction, or it can be far simpler and just allow for some notice and the ability for other parties to bring higher and better offers. Really depends on the order appointing the receiver, other orders that would be entered in the case, and the exact circumstances of that case. But once all the assets are sold, then the proceeds are distributed to the creditors pursuant to the security interests and the underlying law. Many of the statutes provide for priority of distribution, similar to a bankruptcy priority of distribution. So as far as the general receivership, that really is, those really are the highlights, although, they can include everything from complicated financing procedures to lengthy litigation. Second kind of receivership I want to talk about more briefly is a selfish receivership. These are receiverships that are started and receivers that are appointed really to collect a judgment, so for a judgment creditor. In these cases, the receiver's duty, rather than running to all creditors and party in interest, runs just to that specific judgment creditor. And once the receiver is able to gather or liquidate sufficient assets to pay that judgment creditor, then the receiver's work is done. They're an option for enforcing a judgment, like a charging order or a garnishment. It's one more way to go after the assets of the debtor to pay that judgment creditor. And then the last kind of receivership is the receivers that are appointed during litigation. These are commonly appointed in foreclosure actions, for instance, and the receiver's job in those matters is usually just to prevent waste with regard to the real estate, to collect rents and any other profits that are available, to make sure that they're turned over to the lien holder, and to otherwise manage the property so that the property of the receivership is maintained while the receivership and the underlying litigation is going forward. But these receivers can also be appointed in shareholder dispute actions. They can be appointed in divorces. And in any case, the goals are at least to maintain everything. And then sometimes there are additional powers that are provided under the order by the court that allows for the receiver to investigate or sell or requires accountings. So those are the three main types, different types of receiverships that might be seen out there. Although, again, it's all the variety based on the underlying order and the law. Thank you.